On July 17, 2025, Tallahassee police responded to a hit-and-run on Tennessee Street. The other driver reported vehicle damage and complained of shoulder and neck pain. Officers traced the suspect vehicle, a Jeep, with fresh front right fender damage, to a nearby apartment complex. The driver was a 19-year-old college student named Kaylee, with zero criminal history. Before asking a single question about the crash, the officer read Miranda warnings in full. Under Miranda v. Arizona, suspects must be advised of their Fifth Amendment rights before custodial interrogation. At this point, Kaylee was not in custody. She stepped outside voluntarily. So why read Miranda early? Because a crash investigation in Florida carries criminal implications from the start. Reading Miranda proactively insulates every subsequent statement from suppression. The officer also triggered a critical legal consequence most people do not understand. Florida's accident report privilege under Section 316.066 subsection 4 protects statements made during a crash report. They cannot be used in court. But that privilege has a kill switch. Florida courts have held the privilege is fully operative only if the statement is not made after a Miranda waiver. Once Kaylee waived her rights, that protection evaporated. Her words became evidence. The arrest charge. Florida Statute Section 316.027 subsection 2A. Leaving the scene of a crash involving non-serious bodily injury. The statute requires 3 elements. First, the driver was involved in a crash resulting in injury. Second, the driver failed to stop and remain at the scene. Third, and this is what defense attorneys target the failure, was willful. The Florida Supreme Court addressed willfulness in State v. Dorsett, 2015. A driver must have actual knowledge of the crash and should have known from its nature that injury resulted. Kaylee claimed the impact felt minor. Jeeps absorb collisions that devastate lighter vehicles. But her own words undermine that defense. When asked about the crash, she said, "I don't want to deal with it." That implies awareness. She also could not distinguish pre-existing damage from new damage on her Jeep. A prosecutor would argue that uncertainty itself is evidence she knew or should have known. The penalties are severe. A third-degree felony carries up to 5 years in state prison, 5 years probation, a $5,000 fine, and a mandatory 3-year license revocation. What elevated this from a ticket to a felony? The injury report. Had the other driver reported only property damage, Kaylee would have faced a second-degree misdemeanor 60 days max and a $500 fine. The other driver's complaint of shoulder and neck pain, that single factor, turned a fender bender into a felony arrest. The injured party's condition, not the driver's perception, determines the charge. Section 316.062 imposed a clear duty: stop, remain at the scene, provide identification, and render reasonable aid to anyone injured. Kaylee fulfilled none of these obligations. Grades. The investigating officer receives an A-. Miranda was administered proactively and explained in plain language when the subject expressed confusion. Probable cause was firmly established before arrest. He consulted his supervisor, requested a female officer for the search, secured the subject's apartment and belongings, and offered to call someone on her behalf. Calm, empathetic, educational throughout. The minor deduction. His statement that the charge would probably be pleaded down to reckless driving approaches legal advice. Well-intentioned and likely accurate, but officers should avoid predicting outcomes. Kaylee receives a C+. She was fully cooperative after contact, waived Miranda, answered honestly, did not resist, expressed genuine remorse. But cooperation does not erase the underlying offense. Had she simply stopped and asked if the other driver was okay, this would have been an insurance claim, not a felony arrest. A moment of panic transformed a minor collision into the worst night of her life. 3 takeaways. First, always stop. It does not matter how minor the impact feels. In Florida, leaving the scene when someone reports an injury turns a traffic matter into a felony. Second, waiving Miranda in a crash investigation eliminates the accident report privilege. Once you waive, your words become evidence. You always have the right to remain silent and request an attorney. Third, panic is not a legal defense. Florida's hit-and-run statute requires willfulness, but courts interpret that broadly. If you knew a crash happened and left anyway, the reason you left is unlikely to save you. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Bodycam, for even more police interaction and courtroom content.